The afternoon docket of the Court of Appeals. I'm Judge Arnold Golden from Memphis. Joining me on the panel this afternoon are Judge Kenny Armstrong from Memphis and Judge Carmer McGee from Savannah. Each side will have 15 minutes, and the appellant can request up to 5 minutes for rebuttal. Mr. Hivner, will you please call the case?
Sima Khayatt Kholghi versus Reza Aliabadi.
All right. Mr. Caparella? You're not on. Your audio is not on.
Okay. Am I on now?
You're on now, yes.
Thank you. My apologies.
Sorry.
Good afternoon, Your Honors. My name is Donald Caparella of the National Bar. I represent Reza Aliabadi, the husband in this divorce case, along with Kim McDonald, who's my co-counsel. She's not online, but she is on the brief. I'd like to reserve 3 minutes for rebuttal.
All right, sir. You may proceed.
Your Honor, I'll begin with the errors on appeal with the trial court's alimony ruling. We've only appealed the trial court's ruling regarding the husband's ability to pay. And we've argued that it's an abuse of discretion because the trial court used the wrong legal standard, because the trial court made no findings as to what the husband's reasonable expenses were. Trial court just found that his income was approximately $400,000 based on a 2018 tax return that the trial court accepted. Both the Barnes versus Barnes and Malkin versus Malkin cases have made clear that it's a clear legal error for the trial court not to consider the husband's reasonable expenses and just look at the overall income. The quote I want to share with you is the obligor's expenses are crucial for courts to consider as income, and they cannot be reviewed, and so the income cannot be reviewed as in a vacuum. So that is the first reason why the trial court erred, because he didn't consider the husband's expenses. Notably, the math, though, even if you just look at the husband's income, doesn't work as well, as the husband is underwater every month. For example, and the math is set forth in page 38 to 40 of our brief, but just basically, if you start out with his income of $396,000 a year, it's undisputed that of that income, $164,000 approximately is rental income that he turns around and pays every penny of to pay a $7 million mortgage on his a business that he has, a business property that he has. So when you take that out of the $396,000, you end up with $231,000. Another $20,185 is phantom income that's only reported on his K-1. It's undisputed that he doesn't get that. And so that gets his cash flow down to $211,000. And of the husband's salary of $204,000, $75,000 of that is paid in income taxes. Now the trial court reduced wife's income calculation by her income taxes as well, so they should be treated equally. So when you subtract all these undisputed amounts from husband's 2018 tax return income, you get $11,352 a month. The wife's alimony ruling was $8,308. That leaves him just $3,044 for his own expenses. Now, going back, the trial court didn't rule what amount of reasonable expenses he should have for his car, for his living expenses, for his food, for any of the other allowances. So with that error of law and not consider his expenses, and just looking at the alimony ruling, he's underwater. So therefore, we'd ask you to reverse his alimony ruling. Now, next, I'd like to turn to the trial court's dissipation ruling. As Your Honor knows, dissipation is spending that is not typical of the marriage. Discretionary spending that continues from the marriage into the divorce is not dissipation. Dissipation is wasteful spending, spending done frivolously and without justification. Spending of marital assets usually benefiting the spouse that's doing the spending. The first category of dissipation I would like to challenge on appeal, at least in the oral argument, the trial court found that that husband made $22,314 of deposits into the adult son's account, but there was no proof that he even made these deposits. The only document showing that the deposits were made was from a bank listing the deposits. It didn't list the source of the deposits. The only testimony about the source of the deposits was from the husband, who says that he didn't make the deposits, except for he did say maybe he made up to $2,000 or $3,000 total. He certainly didn't make the $22,314. So given that dissipation is required, the wife would have the burden of proof of proving that dissipation. We submit that there's simply an absence of proof that the deposits were even made by the husband in this case. The next category that the trial court made that we think was error, that was the payments made for the adult children. $78,300 was treated as dissipation by the trial court, and related to the following categories: the daughter's apartment's rent, the daughter's utilities, the daughter's car note, and the son's rent and the son's car lease. Now, the record showed, and there was a business ledger that showed this as well as Mr. Aliabadi's testimony, that these were the kinds of adult children expenses that were paid during the marriage that the wife never complained about. And they did continue into the divorce for a time. And then when the trial court raised an issue about this, the husband stopped. But still, the trial court ruled that every dollar of that $78,300 for the adult children's expenses was dissipation. Remember, dissipation is supposed to be benefiting the spouse or be somehow atypical of the marriage, but here it was consistent with the marriage. The trial court also found that $40,000 of payments to the children's uniform transfer to minors accounts was dissipation, and yet that also was something that that both parents acquiesced in during the marriage, because they would put money into their children's accounts under the Uniform Transfer Minors Act. Again, you have a continuation of typical expenses into the divorce that the trial court just simply arbitrarily found was dissipation. And then the last category I want to talk about, last two categories, had to do with the husband's car payments. Husband had a Porsche under lease for about $1,300 a month during the marriage. That lease expired during the divorce. He then purchased a Porsche instead of leasing a Porsche for $1,900 a month. And the trial court dissipated the entire $44,342 that he paid over the 23 months during the divorce. Husband had to have a car to go to work. He testified that he had a luxury car as part of his normal business because he wanted to show that he was a successful businessman, and he did it, and everyone acquiesced to him having that kind of a car. He bought the same kind of car that he'd been leasing during the divorce, and yet the trial court dissipated the entire amount. So he needs to have a car expense, and that was improper to be used to dissipation. Then the last category the trial court dissipated was husband's rental payments. Husband moved out of the marital home after the divorce was filed, and he lived in an apartment charged and rented it for $3,000 a month. The trial court said, you must live in the Cinnamon Place property, or I will treat all of your rent payments as dissipation. The problem with the Cinnamon property was that it was only owned 50% by the husband. His father owned the other 50%. He normally received rental income from that property. It was also occupied 2 weeks out of the month for most of the year by an engineer that came and worked for his business. So it was not like he could just simply have a free place to live, and the trial court was arbitrary in saying that he would treat all of his rental income as dissipation. Certainly, husband needs to have an appropriate amount of expense to spend to live somewhere, since he couldn't live in the marital home anymore. So the trial court erred by treating all that as dissipation. So altogether, that adds up to $249,000 of dissipation, and we submit that all of that should be set aside. And since the trial court sort of embedded this dissipation ruling inside the property division ruling, this would require, because that's such a large amount of money, would require a reversal of the entire property division. So now the last category of expenses, the $182,000 for a catch-all category for husband's travel, there was never any accounting for that. And even opposing counsel in their brief agreed that not proper findings were made on that additional amount of dissipation. So we would request that you remand this entire case for redoing the property division and also setting aside all these dissipation rulings, because the trial court didn't make proper findings to support those. Another issue on appeal is the trial court ordered a husband to pay all the expenses of the marital home until it was sold in a pendente lite ruling in approximately 2017. The final decree didn't get entered until 2018, and the house still hadn't sold, and it still hasn't sold. So husband has been required to pay all the expenses of the home, the mortgage, utilities, etc., adding up to about $11,000 a month. On top of that, he's been paying a pendente lite alimony ruling of $7,000 a month. Remember, the alimony ruling of $8,300 doesn't even kick in until the marital home is sold. However, even though husband has paid that for over 20 months now, adding up to almost $360,000, nowhere in this marital property division is that accounted for. That's a transfer of $360,000 so wife can stay in the marital home, and it's not accounted for. We're asking on appeal that you remand to have the trial court give him credit for that $360,000 and anything else that he has to pay before the marital home has been sold. Excuse me. Lastly, the trial court made a legal error in that in order to do a property division, the statute requires you to consider the parties' separate property. In this case, the trial court found that the wife owned separate property in Iran, a 1/3 interest in her mother's home. And her mother's home was an unusually large home, 20,000 square foot house, 5 bedrooms, elevator on each floor in one of Iran's largest cities. The husband testified that he tried to get it appraised, but that the wife's family rebuffed him and would not let the appraiser come in. Now, opposing counsel has said that that's not proper evidence for you to consider. But in our reply brief, we showed that all the objections they raised to the testimony about whether the appraisal happened did not relate to the husband's testimony. It only related to his testimony about what he spoke to his lawyer about. So we believe that's proper testimony for you to consider. But in any event, wife testified in an interrogatory that that property could be worth as much as $850,000. And in another statement she made under oath, it could be worth as much as $7 million. That's a very substantial piece of property that if the trial court had considered the value of, could have changed the property division. And since the trial court's required to consider the value of wife's separate property, and the trial court found that she indeed owns a separate property, we submit that the trial court erred as a matter of law in not considering that, and they should remand the property division as well for the trial court to consider that separate property. And then lastly, just saying briefly on opposing counsel's cross appeal, we submit that they are not entitled to additional attorney's fees in the trial court, and certainly are not entitled to appellate attorney's fees, because the claim that we made misrepresentations to this court in our brief is simply without merit. So thank you, Your Honor.
Thank you. You have your rebuttal. Ms. Rogers?
Thank you. May it please the court, I'm Helen Rogers, along with my associate Stella Cam, and we have worked on this case and represented Mrs. Kholghi throughout the trial. There has seldom been a case, although in almost every family law case we have what we call divorce flu, where the husband's always having his worst year ever. This husband did incredible things to diminish his earning ability and his income. He wrote off the sale of carpets to the tune of $641,000. He wrote off another intercompany transaction receivable for $410,000. He increased his inventory in the business by $400,000, took out owner equity distributions, which is Exhibit 63, of $1.1 million. And then he borrowed additional $205,000 on real estate that the company owned that was personally titled to him, that the company operated on. So he did virtually everything you can imagine to reduce his income and earning ability while the divorce was pending. Mr. Caparella simply is misstating his income. Yes, for income tax purposes, his average income was $300,000. But their own expert, Vic Alexander, in Exhibit 86 to the trial, says that his average pre-tax, pre-interest income, the money that he had available to him without taking into account depreciation and those things, averaged $643,259 a year. And that was not disputed. Both of the business evaluation experts agreed that was Mr. Aliabadi's income. The alimony award in this case was very reasonable for that income level and for the lifestyle the parties enjoyed. They lived in a 12,000 square foot home, 6 bedrooms, 9 baths, 2 kitchens, and a swimming pool. That is the lifestyle that my client enjoyed in this marriage. And he clearly has the ability to pay. To claim that the trial court, by not going through each and every aspect of his expenses, should invalidate the alimony award is simply disingenuous. There were 2 exhibits introduced at trial that the court had available to him, Exhibit 30 and Exhibit 42. Exhibit 30 was his initial income and expense statement, where he showed $7,500 a month being spent on adult children. Now, he doesn't want to support his wife of 30 years at the $8,300 a month alimony, and he wants to get credited back, leaving her in a house. And the date of divorce Mr. Caparella gave you was incorrect. It's not 20 months. The date of divorce was June the 27th of 2019, just a year ago. So there's only been 12 months since the divorce, and he's continued to pay the house payment. But here's a man who can afford and files an income and expense statement for $7,500 a month for adult children. The daughter had already graduated from college. There was no reason to ever contribute to a Uniform Gift to Minors Act when neither of the children were minors. He put $40,000 in their UTMA accounts during the divorce with the statutory injunction in place. I mean, if that's not dissipation, I can't imagine what you would find as dissipation. That the daughter had already graduated from college. How can she need any more educational money? She was 26 years old. And we cite in our brief, of course, the UTMA statute that says it reverts to the child at 21. And then Exhibit 42, the same thing. He's got expenses listed there. The court, I don't think, had to really look at it, because given his income level, he had the ability to pay. The only time that his income and expenses would come into play is if he didn't have the ability to pay. His own income and expense statement proves his ability to pay, because if he can pay that for adult children, he can certainly pay it for his wife. On the issues of dissipation, and so we're asking the court to affirm, this court to affirm the trial judge's ruling on alimony. It is certainly well deserved. My client was obviously the economically disadvantaged spouse. Her reading level was 6th, 7th, 8th grade level, and her math level was at 4th and 5th grade. She obviously needed help. The business evaluation expert was undisputed as to her needs. And so all of that comes into play in the reasonableness and the correctness of what the court did. This trial court did a very detailed decision. And the hardest thing in this case was getting a hold of Mr. Aliabadi's income, because of all these gyrations he did within his business. And so if you look at one of the biggest things on his income is Exhibit 63, the owner equity distributions, which will show you that Mr. Aliabadi basically used his company as his bank. Whenever he needed money, he just pulled money out. And he occasionally repaid it, but the judge made a specific finding that Mr. Aliabadi would not likely pay all of this back, and he made a specific finding that Mr. Aliabadi would inherit the other half of this business because he was an only child and in business with his 87-year-old father. So we very clearly have shown, and you will see this owner equity distributions makes it clear that Mr. Aliabadi has whatever money he needs when he needs it from his business in addition to his paycheck. There are, as I said, he pulled $1,143,473 during the pendency of the divorce out of the business. But he called it owner equity distributions. And we introduced into the hearing his deposition testimony where I asked him, why do you do this? And he said, well, for the taxes. In other words, rather than paying income tax on pulling distributions out of his business, he called it shareholder loans. But his actual CPA in his business headed that sheet as owner equity distributions because that's what they really were. And so Judge Robinson elected to treat this as dissipation, that he was reducing the value of the business and spending money. And each of these dissipation categories are reasonable. Buying a new Porsche in the middle of a divorce where you've got $2,000 a month car payments is exorbitant. It was offensive to Judge Robinson, and he viewed that as dissipation. $3,000 a month for an apartment, Judge Robinson told him at the very beginning in the Pendenny Light order that he would consider that dissipation at the final hearing if he chose to stay in the apartment. He owned a 4-bedroom house with his father that was only occasionally occupied by an engineer that came from out of town, 4 bedrooms. And yet he chose to spend $3,000 a month on an apartment. Meanwhile, whining that he should be reimbursed for things that he did for his wife of 30 years who never worked outside the home. The children's personal expenses, those were clearly dissipation. Now, yes, you might have done that during the marriage. My client had no idea what was being done during the marriage. She didn't even know how to write a check. And she had no access to their finances. But once the divorce starts and your spouse says, I'm not okay with you doing that anymore, you've got to support me. Wife comes first. And I think that's a very clear issue. Now, we don't have a lot of law in Tennessee on this. We looked very thoroughly to see what is there in Tennessee about dissipation when it comes to spending money on adult children. And that's why we brought in out-of-state jurisdiction, out-of-state authority to show you that other states have treated these things as dissipation. And yes, not every state statute is exactly like ours, and not every fact of those cases exactly beats ours, but there have been many sister states that have found spending money on children adult children is dissipation in a divorce. And then the son's separate account, if the court will look at Exhibit 109, husband had no explanation for how this money got in the son's account. It was a jointly titled account, but he did say it was probably payroll checks and money that he had put in. So yes, he didn't identify each deposit, but the payroll checks were from husband's business to the son. And so those, and then it is true, we proved in exhibits 17, 18, and 19 that husband on some of these out-of-town trips had another person staying with him or another person and a child staying with him. And so the trial court did charge $182,043 for dissipation on other people and charges that he had put on the business credit cards for personal use. The court had access to those. They did not give us as detailed of an accounting. And as we tell you in our brief, there's about a $79,000 difference that we can't account for. I don't know that that's not perhaps de minimis given the entirety of the situation. As to the marital home, the court entered an order at Mr. Caparella's motion yesterday that provided for the parties to divide any proceeds ordered in the final decree after the home is auctioned, and that house is going to be auctioned. And I will file a motion to supplement the record so that you know that, but my client is very likely going to lose the $600,000 or roughly that was going to come to her. She was supposed to get 60%, and then the other 40% was to be credited against the judgment she has against the husband. And so this auction is likely going to result in very diminished assets. And after 30 years, he's going to end up with a multi-million-dollar business, and she's not going to have the funds to even purchase a new home. And so that is, I think, most of the issues that Mr. Caparella raised with you with regard to the marital home is moot at this point. Mr. Kholghi only continued to pay the house note for 1 year after the divorce. I don't think this court can go back and give him credit for 20 months that they're requesting. And that was a reasonable thing to do. I mean, someone had to live in the house, someone had to have it available for showings and try to market it. Mr. Aliabadi voluntarily moved out of the marital home. I mean, 12,000 square foot home, he didn't even need to have an apartment. They certainly could have lived in separate areas. And as I said, it had 2 kitchens. So it was a very unusual situation. As to attorney's fees, our only cross appeal is that the judge was kind of stingy with attorney's fees to Ms. Kholghi in the divorce, and this court should also consider her situation as the economically disadvantaged spouse on the appeal. The property in Iran was something that we wasted, in my opinion, a lot of time and money on at the trial, and the court said, well, she hadn't been totally forthcoming. Well, Ms. Kholghi didn't have the education. Her testimony about the Iranian property is, I signed over a power of attorney to my sister. My sister handled it. It was a long, complicated mess. There were creditors against her father, and it was just, it's property in Iran. It's worth nothing to her. She hasn't been back to Iran in 7, 8 years. She has no plans to go back. There's nothing there for her. Value is speculative at best. There's no way to deal with this effectively. And if you look, you can't even bring money back from Iran if you tried to. In any event, we were about $70,000 in attorney's fees and expert fees that were not provided for in the final decree that Ms. Kholghi is supposed to somehow pay. And they're just, again, we're not supposed to dissipate assets for attorney's fees if it's not necessary. Husband has at least close to $650,000 a year of income or more. He can draw on these business loans to himself from his own company at any time and at will. And so we're asking this court to affirm the trial court's decision, award her attorney's fees, additional attorney's fees for the trial, and attorney's fees for this appeal. Thank you very much.
Thank you. Mr. Caparella, you have 3 minutes.
Thank you, Your Honor. Your Honor, the attacks on husband's income, or particularly the trial court's ruling that his income was the $396,000 in her tax return, in his tax return, is not even properly before this court because they didn't raise it in their issue statement in their brief, and they haven't challenged on appeal the trial court's rulings. And the suggestion that the reason why you should affirm the trial court's ruling on the alimony is because he actually had a lot more income than the trial court found is not an appropriate issue before the court because it's not in their issue statement. Therefore, it's waived on appeal. All this discussion about the write-offs and the property and the valuation of the business also is not an issue in this appeal. We didn't challenge the business evaluation. All we did was challenge the dissipation that reduced the value of the business. They've not challenged the business evaluation, so that's all irrelevant and waived on appeal. The arguments that these loans were somehow not legitimate or improper is also waived on appeal. We put in our reply brief 9 different categories of things that they supposedly are talking about in their brief that were not in their issue statement. And the whole idea that the loans that the trial court expressly found were legitimate loans because they were used to pay for the personal expenses of Mr. Aliabadi that benefited the wife. They can't raise that in the oral argument or in their brief because they didn't properly raise it on appeal in their statement of issues. The loan is a legitimate loan up to 1.35 million. The only issue we have is whether the trial court improperly reduced the amount of the loan from 1.78 million to 1.35 million with these issues related to dissipation. So lastly, opposing counsel made a startling admission, I thought. She said, it doesn't really matter that these expenses for the children or his car payments or whatever were made during the marriage. Now that they're in a divorce, it's going to be dissipation if he buys a Porsche to replace the Porsche that he previously had, or it's going to be dissipation if he continues to support his adult children during the time of his marriage, during the time they did during the marriage. And yet the whole essence of dissipation.
Cabral, how can he afford to continue to support his adult children, but he can't afford the alimony in this case?
Well, he stopped supporting his adult children when the court asked him to stop during the divorce. They're asking for, he's not trying to continue to do it. There's no evidence that he continued to pay the children until once the trial court asked him to stop. The question is whether or not that was dissipation for him to do it when he'd always done it. And
I understand, but you're saying he doesn't have the income. You don't have the income to pay $8,000 a month in alimony, but he had the income to continue to pay that kind of money to support his adult children.
The calculation that we did for the alimony doesn't even consider the payments that were made to his adult children. And then that was the problem with the trial court, is the trial court didn't even make any finding as to what any of his reasonable expenses would be as to food, housing, anything else. So that's the error of the alimony, is the trial court made no finding as to his actual expenses. The whole idea of dissipation for his adult children is not relevant to the issue of whether he has the income now, because we've already removed those in our math calculation in page 38 to 40 of our brief.
Okay. Thank you very much. We will get you an opinion as soon as possible.
Thank you, Your Honor.
All righty.
This honorable court is now adjourned.